I bet you can hear me a lot better now. And so I'll go ahead and restart. So today we're talking all about whether the big question for today is, can a landlord legally enter rental property for a repair or an inspection? And how does that work? Now, for those of you who know, I predominantly work in the state of Texas. And in fact, I exclusively work in the state of Texas. And let's see. Okay. Hello, James. I see Lorena. Yeah, sorry about the sound. Anyway, so I exclusively work in the state of Texas, and so much of what I'm going to say is based on a Texas perspective, but a lot of what I'm going to share with you is applicable across the United States. There may be rules that you're going to have to consider with regard to entering real property. And so I'm going to, glad you can hear us now, James. Thank you so much. I'm going to go ahead and, talk about things in general. I'm not going to mention specific code provisions because I know that can affect your right to enter. If you've got specific code provisions, and rules and lengths of time and things of that, I'm not going to get into that. But I'm going to talk about the right to enter in a general sense and the kinds of things that I recommend to landlords all the time when it comes to entering property for repair or for inspection. So we'll go ahead and get to that in just a second. But we also have multiple questions that we receive from people who are on our Facebook group. If you are not a member of Texas Landlords and would like to be, we welcome you to check that out. If you're already on Facebook, you really should be a member of Texas Landlords on Facebook if you've got property in the state of Texas that you manage, own, or lease. For everybody else, if you're interested in getting on our mailing list, we definitely welcome you to do that. You'll see along the bottom our phone number if you want to send us a text. You'll also see the email address that you can use to reach out to us if you're interested in joining our mailing list. Every Wednesday when we get together, I get a list of questions that I pre-screen and prepare for so that I can give you the best possible legal advice. Let me correct that. So I can give you the best possible legal information. We don't give legal advice here because we are not establishing a attorney-client relationship. But I can talk in an educational format and inform you on the kinds of things that I would suggest in certain legal situations. So I'm going to get started on that in just a bit. But first, our topic. So if you do have a question and have not already contributed to us, feel free to add it into the chat and I'll be happy to answer that question as we go along. So today's topic, can a landlord legally enter into rental property for the purposes of a repair or an inspection? And the simple answer is maybe. In fact, it's usually probably yes. But there's some things you have to consider first. And the very first thing you have to consider is, what does the lease say? Because that's going to be your controlling document. And the truth is, if you're in a situation where you only have an oral agreement, and the state of Texas does allow oral lease agreements, so these kinds of things are still stuff we have to talk about because from time to time, that's all the landlord has. If you've got an oral agreement, you've really only got two promises in there. The first is the address of the place. What is the address of the rental property? That's one of the promises. That's the property you are leasing. And the second is some promise to pay rent. But even that is not well articulated when you don't have something in writing. So we know there's a place and we know there's a promise to pay something in rent, but that's about it. And so I don't recommend oral lease agreements. They're extremely difficult to prove. But if you've got a written agreement, and most landlords do, what does it say about your right to enter? You'd be shocked how many landlords have written leases and have been using them for years and don't know their own rights. They don't know what their lease already allows them to do and what the parties have already agreed to in terms of the landlord's right to enter the property. Many times it's right there in black and white. And all you gotta do is follow what's there. You've already come to that agreement. You don't have to bring the thing up again like it's a brand new term, because you and that tenant have already explained in that written agreement what the extent of your rights are and what limitations you've got if you've got a well-drafted lease that is particular to your state. So first and foremost, you're always going to look at your lease and make sure that it mentions something about your rights to enter in these situations. That's going to answer most of your questions right off the bat. So then, what's next? After you've confirmed that you do have this right under your lease and you've confirmed what your lease says about it, what's next? So the next thing is, did you give proper notice? Now, some of you, especially those of you advanced in landlord tenant law, are going to say, Ernie, my lease doesn't even require that I give notice. I can just come in unannounced. Well, that's not true in all cases. So especially if you're in a state that doesn't allow you just to walk in without any kind of notice, if your state absolutely requires it, that's one thing. But your lease, because even if you're not in a state that absolutely requires it, but if your lease absolutely requires notice, make sure that you're giving notice in accordance with that lease, because the lease may or may not be required. But if you don't know whether it is and you enter anyway, you may be in breach of your own agreement because you're not following what your lease has to say. Wanda, hello, I see you there. And so what does your lease say? And are you required to give notice? Now, I tend to recommend to landlords to give notice whether the lease requires it or not, whether your state requires it or not. It's always a good idea to give notice that you're going to be on the property to do some repair or to conduct an inspection. And usually I would say if you're not giving at least 48 hours of notice, you're probably erring on the side of risk. Because first of all, it's just a bad customer service thing not to give some kind of notice if you can. It's not always possible. In emergency situations, you're less likely to have time to give a proper notice. But if you can give a notice, you absolutely should. And so, your notice provision is a whole other section of your lease, and hopefully in your notice provision, you've got multiple means of getting a hold of your tenant. Personal email, work email, some kind of tenant portal, maybe a messaging app. And of course, the old-fashioned, I walked up to your door and left you a written notice or put a written notice in your hand or mailed a written notice to you so that you had it in time for my repair or inspection visit. If that's the case for you, you're always going to be on the better side. You always want to err on the side of caution and not on the side of risk, because you want to be able to deliver, number one, a good service to your tenant, but number two, you want to be able to be safe when you're there and not have someone suspect a burglar or suspect a prowler, suspect some kind of malfeasance, and boom, you get blown away by mistake. Now, I'm not saying there's a huge risk of that happening. That's not usually the case, but it's 100% avoidable because you gave proper notice to your tenant. And even if your lease isn't a requirement, even if it's not a requirement under your lease, it's just a good idea. It's a good customer service to give some kind of notice in writing in advance to your tenants, at least 48 hours ahead of time that you're coming onto the property. Okay. Next thing to consider is, do you even have a valid basis to be there? Because if you don't have a valid basis to enter, I can't agree that you should be there at all. You can't just show up because. And any landlord who treats their tenant this way is just asking for a harassment lawsuit. So don't just barge in because you feel like it. Make sure if you're going to enter, you have a valid basis. That includes a right illustrated in your lease. If your lease doesn't out and out say you have this right, then maybe you shouldn't be on the property. And so make sure that every time you schedule or you give notice of your intent to enter property, it's because you've got a valid reason to be there. Certainly a repair is that, and an inspection can be that, but I mean, there's certain times when inspection just doesn't make sense, especially if you just did one like a weekend before. So, make sure that you've got a valid reason to be on the property, and that's always going to help. The next consideration is, are you showing up at a reasonable time? Because if you're coming in at 8:30 in the evening, that's probably a terrible idea unless you and your tenant have arranged for that time. It's probably not reasonable. Rule of thumb is you come in during normal business hours, 8 to 5, 9 to 5. That makes a lot of sense. But you may say, Ernie, I've got a tenant who, he works nights. And so he prefers that I show up in the evening. Fine. It might be reasonable for that tenant. That doesn't mean it's reasonable for all tenants, but make sure that whenever you plan to enter the property, it is at a reasonable time. Of course, emergencies, emergency situations can affect the reasonableness of the time you elect to come onto the property. That's for sure. But you want to make sure that if you're pre-scheduling this, that you're doing it in a way that makes sense and that is reasonable. So that's your next consideration. And the last one, can you enter in a peaceful manner? You certainly cannot just barge in, guns blazing, saying, I'm coming in no matter what. You cannot stop me. I'm a bulldozer and I'll knock down that door. I'll kick it in if I have to. That's not a proper way to enter the property. And again, you're probably going to get hit with some kind of harassment allegation if you're coming in an aggressive manner. The rule of thumb in Texas is you come in with a valid basis at a reasonable time and in a peaceful manner. Now, what happens, however, if you're perfectly calm, you're perfectly peaceful, you're following all the rules, but your tenant breaks the peace? Your tenant starts stomping up and down, yelling and screaming, calling the cops, saying, you are not coming in this house. Can you enter? Well, definitely not in the state of Texas. And it's just not a good rule of thumb for you to believe that even though your lease says it, your state allows it, and you've shown up there with a valid basis at a reasonable time and in a peaceful manner yourself, that you should be able to walk through that door. The law is going to protect both you and this tenant. So if the peace is broken by either yourself coming in an aggressive manner or by your tenant in a hostile way, preventing you from coming in, you actually cannot enter at that point. Your right to enter terminates because that tenant is no longer himself or herself acting in a peaceful manner. Now, does that mean that the tenant gets to call all the shots? That doesn't sound fair. No, absolutely not. That is a huge violation of the lease by the tenant, because if the lease says you can otherwise enter as long as you abide by all these other criteria, you gave notice where it was necessary, you came with a valid basis, and you came at a reasonable time, and you were there in a peaceful manner, as long as you abide by all of these, and there's no other prohibition, the only reason you couldn't go in is because the tenant broke the peace. That's a violation. And you can even point to the provision in the lease that says, look, I had the right to enter, but I didn't because you broke the peace. That's notice of default. Send that notice every time. And then if you try again and again, and the tenant multiple times denies you access, that's probably a good sign you've got a bad tenant. And so after 3 strikes, it's my policy. 3 strikes, I'm sorry, you're out. You got to go. I've attempted to, again, come in accordance with my lease, in accordance with state law, sent you notice, came with a valid basis, came at a reasonable time and in a peaceful manner. I checked all the boxes. You broke the peace. I'm coming in. I'm sorry, you broke the peace, and so I'm saying here is your notice to vacate after 3 successive notices of default, and so now you got to go. And so I'm headed to the eviction court and putting you out for lease violations. And this is even if the tenant has previously paid their rent. They're just not allowed to deny you access in this way, and you shouldn't stand for it, because all you would be doing is condoning very, very bad behavior. So again, for those of you who have not submitted questions ahead of time, if you want, you can add them to the chat. I'll be happy to answer your questions. But for everyone else, I've got prepared questions for you right here, and I would like to get into those next. So here is question number 1. If we were granted eviction judgment in June of 2025, so that was just a few months ago, can we currently request a writ of possession, or do we have to refile for eviction? Now, this is going to get a Texas-specific answer because I've got a Texas-specific rule. The Texas Rules of Civil Procedure say you got to get your writ within 60 days of judgment. It is possible to extend that up to 90 days. But if that happened anytime in June, July, August, September, we're now in November, you don't got a hope. So unfortunately, you will have to refile for another eviction. And this happens sometimes when, you file the eviction, you win your eviction judgment, but the tenant begs and begs and comes up with cash and says, here you go, take this money, and you take it. And it's okay for the first 30 days. But then they just slip right back in and they don't pay. And what happens? You've got a worthless judgment sitting down there. Now, they've got this smear on their eviction history, but you're the one who neglected to pay attention to it and act on it. And so now you're stuck having to refile. After 90 days, there is no way for you to get a writ of possession. And even if you were within the 90 days, it would be very difficult to both purchase it and have it executed within that time frame. Really, if you're not doing it within the first 30 days, you really run a risk that you're going to have to refile. So unfortunately, Christina, that's probably going to require a new case. I don't know exactly what the case facts were, but after 90 days, it is 100% impossible to get a writ. Let's see, Wanda says, if you text a tenant that is very hostile towards you, and you tell that tenant that you are going to deal with ignorance or stupidity, is that the basis for a tenant to use against you in the court? I'm guessing, Wanda, you mean you're not going to deal with ignorance or stupidity? Probably not. I mean, certainly, okay. My advice to landlords is always, when it comes to confrontations, is make sure that anything you ever say is something you would be 100% comfortable having said in front of a judge, right? So if you're replying to one of your tenants and you say, you are a mother this and a son of a that, and I'm going to blankety blank and ... It doesn't look good. It doesn't necessarily mean that it is illegal or there's some kind of breach of your lease, but man, it doesn't look good. And could it have some effect? Yeah, in an egregious enough situation, it could have some emotional effect on the judge, who might say, you know what, you're asking for help, you're acting like a jerk, I'm not doing it, case dismissed. Or I'm just denying your motion or your pleadings outright. And that's unfortunate. But in this situation, I just don't think that what you said, I see that. So you're not going to deal with ignorance or stupidity. Generally speaking, this kind of language, it just isn't egregious. And, you're allowed to be opinionated. To a certain degree. I don't think this would affect you in an eviction or in some subsequent case, because I don't think it actually violates the lease, and it's not aggressive enough to be termed some kind of terroristic threat to rise to the level of criminality. So again, that rule of thumb, your communication should always be in a business-like manner, and you could just ignore ignorance and stupidity. You don't have to reply. And so, again, if you wouldn't be proud to present it in front of a judge, or you would be a little embarrassed if these words were read in an open court, then I would never send them. If you keep your communication between you and your tenant always in a business-like manner, you're always going to be proud to present whatever it is in front of the judge, because your communication should stand out. And if their communication is poor, well, let the court use that against them as you seek to recover property or recover a judgment against them. So, all right, question number 2. How do we protect ourselves from mold-related issues with tenants? Well, I've got lots of content on this very subject because mold is a pretty prevalent thing, particularly in the state of Texas, but it's everywhere. You know, anywhere you have some kind of heat and some kind of moisture, you're likely to have mold. But mold isn't all that bad. You know, we get a certain growth, you know, pretty commonly in our bathrooms, for example. You see that mildew starting to form, you know, around our showers, maybe under our sinks, but that's not lethal amounts, right? You know, I often tell people, or relate it to certain things, like alcohol, for example. Can someone die from excessive amounts of alcohol? Absolutely. Do most people feel zero effects from a single drink? Yeah, I mean, that's typically the case. You know, most people are not going to be harmed by a small amount of alcohol. And so when it comes to mold, there are certain things you can do to protect yourself all the time. Number one, make sure that when you lease property to someone, you've inspected it. And what you're looking for to protect against mold are leaks, because every instance of mold comes from some moisture source. And so what typically happens is there's a moisture source, sometimes, you know, a dripping faucet or a pipe behind a wall that's leaking slowly, feeding the mold, and with heat, it grows. And so the moment you find that mold is growing, you need to deal with it. And so you find the leak, you repair the leak, and then you take out whatever has been damaged by that mold, and you remediate it. Now, there are various ways of remediation. Sometimes it's as simple as household cleaners. Sometimes when the mold is much more widespread, you need professionals. And what the state requires is if you've got mold covering 25 contiguous square feet, so it's a 5 by 5 inch patch on a wall, for example. If I said 5 inch, I meant 5 feet. 5 feet up, 5 feet across. The whole wall is completely covered in mold in this 5 by 5 section or more. You're going to need a professional to come in. But if it's a tiny spot here or there, a little bit of mold on the vents, something under a sink, you can, and you don't need a specialist to do this, you can go with household cleaners usually and either carve it out or clean it out. And as long as you have, number one, eliminated the source of moisture, and two, you know, removed any present mold, you're fine. And so if someone makes a claim and they believe there's mold in the house, you need to go and give it a legitimate check, because it's probably coming from some water source. And there are two kinds. There are sources fed from the house and there are sources fed from the people, right? So fed from the house would usually involve a leak of some sort. Fed from the people usually involves them applying moisture where moisture does not belong. If you've got kids and they leave their wet towels after a bath or after a dip in the pool on carpet, and they leave it there for a long time, you might lift an old towel and find mold growing underneath that towel. It's disgusting. It's going to stink. But if left unattended for long enough, those are the recipe. That's the recipe for mold growth. And so, you know, You can prevent this, number one, by instructing your tenants not to do these very things, to report leaks regularly. But you also have to be on the property regularly, making sure that everything is in tip-top shape. I recommend in any 12-month period that you're there at least twice. You go in, you check the floors and the walls and the ceiling. You check the drip pan from the AC, make sure it's not overflowing. You check the pipes to make sure there's no leaks and no evidence of mold growth. You see black spots, you probably got mold. You've got water where it doesn't belong. So you go in and you eliminate that, so you protect yourself. Other than that, there's not a whole lot you can do, because again, mold will be there. If someone makes a complaint, you have to respond with diligence. Go check it out, remedy the source, and remove the mold. That's the best advice I can give you. If you've got a moldy house that you've neglected and somebody legitimately gets sick, call an attorney, because if you have injured your tenant by neglecting a leak or some legitimate mold claim and believing that's not your problem, well, it might actually be your problem. But otherwise, if you catch stuff early enough, it's not going to result in any kind of harm. And by exercising your duty to repair with diligence, you're going to be out of harm's way. If a lawsuit's ever, filed against you, as long as you can prove what you did to remedy the situation and you acted in a reasonable manner, those lawsuits usually go nowhere, right? It's usually the cases where landlords neglect legitimate reports, and then they go to a doctor, they develop, they have some kind of allergic reaction, or they have, bronchitis or something. And now you've got real medical claims that were exacerbated probably from excessive mold on the property. And so you get a report, deal with it. You find a leak, deal with it, remedy the source, and remove the mold 100% of the time. So I hope that was helpful. Let's see, Alexander. Here's how I handle an unruly tenant. I calmly say, I understand your concerns. Please email or text me the details so I can document and resolve the issue properly. Yeah, I think that's good advice whenever someone is, being obstinate or they're being hostile. I often tend to say this to landlords is, if you're communicating exclusively in writing, yeah, they might get out of hand. You're going to always stay businesslike. But if they insist, no, I will only deal with you in person, or I'll only deal with you on the phone, because they want to yell and scream at you, why would you subject yourself to that? It doesn't make any sense. Shut that down and say, sorry, we're going to communicate in writing only. And so you're free to email me, you're free to write me a letter. But I will not engage in oral communication, because my preference is always to preserve a record of communication of what is said. If you have a request, send it to me in writing, please. Always, always, always a good rule of thumb. All right. So let's see. We are on question number 3. When a tenant is evicted, do you legally have to send a move-out report? Sanvia May Duncan. Okay, so I'm not sure what you mean by a move-out report, but I think what you mean is an itemized list of damages after the tenant has vacated. And I know that in your original, you said that you're finding conflicting information. Well, let me resolve this even with that conflict, because the Texas Property Code says that if a tenant leaves owing some amount of rent, they are not due an itemized list of deductions. However, I always advise every landlord that comes across my way in this situation, send that itemized list of deductions anyway, even if they're not owed it. Why? Because even those terrible, terrible tenants will file a lawsuit against you for wrongful withholding, because they go on the internet too and see, oh, wow, did your landlord fail to supply you with a written notice of each of the deductions to your security deposit? If not, you might be entitled to 3 times that deposit amount, plus $100, plus all of your attorney fees. And so to avoid that, you always want to send that itemized notice. And I like sending it within 30 days of them vacating. And so if you're in a situation, even in the event of an eviction, when you've got a security deposit, always send that notice to them and always inform them you damaged this and you damaged this and you owe 4 months of rent or whatever the case is. And so based on that, your deposit amount is exceeded by the debt that you continue to owe on this lease. And because of that, you will not be receiving a refund. And so you shut down any potential claim because within 30 days of them vacating, even though they weren't entitled to any of that refund, and even though the Texas property code says they're not entitled to even a notice regarding their deposit, you're sending it anyway because you're trying to prevent them from foolishly suing you. They still might, but at least this way, you've got the evidence that you can present to a court and say, Your Honor, there's nothing here. I sent an itemized notice. They owed me 4 months of rent. This case should be dismissed. Or, Your Honor, here's my counterclaim against this tenant. Yeah, I won a judgment against them in the eviction court, but they actually owe me in excess of that judgment several $1,000s more, and those amounts exceed the deposit, and because of that, I'm entitled to an additional judgment against this same tenant. So those are your options in that case, but always, always, always send that itemized list of deductions. I think it is helpful. Okay, Wanda A says, gave a 30-day notice to vacate, but tell the tenant that you will not accept any payments, but then tell them that you had to verify with your lawyer and tell them to pay. Would court hold that against you? Maybe. If you tell someone to leave and you sue them for an eviction, and then you go and say, do you want to pay me money? And it's not clear how that money is being applied. Yes, you could end up ruining your eviction petition. I see this all the time from landlords. Instead, what I tend to recommend is you want to make sure, just like with communication regarding repairs or other things, that your acceptance of any money after you have demanded that the tenant vacate, after you have filed an eviction, that your attempt to collect any money is all done in writing so that it's 100% clear. If what you're saying is, look, I still want possession, you still must leave, but I will accept your money. And if you leave by date X, I can dismiss the lawsuit against you so you don't have an eviction on your record. But if you fail to do that, I will proceed with the eviction. Or in order for you to stay, you've got to pay this amount. Any amount less than that will continue to result in an eviction. And if they say, well, will you accept half? Sure, I'll accept half. But until I get the other half, we're still proceeding with the eviction. And they say, no problem. We want to do this. If that's not explicitly stated in some kind of written format, then you're kind of asking for a lawsuit, or you're asking for your lawsuit against them to be kicked out on the basis that you entered into a new deal. By accepting the money, it could be argued, you have agreed to extend possession. And because you agreed to extend possession, your claim for possession in the current eviction is moot. It's no longer valid. And so don't shoot yourself in the foot by accepting money without it being crystal clear how that money is being applied and what, if anything, accepting that money gains the tenant. If you had one idea and they had a different idea, if nothing's in writing, that's how you ruin your eviction case in that situation. So I hope that's helpful. So for the future, let's see, Wanda says, I am evicting for other reasons than non-payment of rent, but they also have not paid the rent. Well, again, if you're accepting money, that could serve as a resolution of those non-rent violations, unless it is 100% crystal clear with some kind of written document. I wouldn't risk it because it can go south. And so I'm glad that was helpful for you, Wanda. Again, any other questions you might have, go ahead and add those into the chat. I'm happy to answer those for you. Now, here is the next question. I know Alexander was here earlier. He had a question. He says, as a Texas landlord, should I update lease forms before January 1st, 2026? Now, he's asking this, and his question makes it clear, because the laws will change. Chapter 24 of the Texas Property Code is undergoing a major overhaul beginning January 1st, 2026. And so the rules for eviction will change. Some of those rules have already changed as of September 1st of this year. Those had to do with squatters, not exactly evictions, but you're no longer required to have to evict an actual squatter. Now, that term is very narrow. I've heard landlords apply it in ways that are not applicable. But if you've got a genuine squatter on your property, you don't have to evict them anymore. There's a form you can fill out, and you swear to each of these criteria. And if you've done these things, and if the situation is as you swear in that form, you can have that squatter removed in accordance with the new laws out of Chapter 5 of the Texas Property Code that have to do with squatters. But you're talking about updates to the eviction procedures that are coming in January. That doesn't necessarily affect the lease or what should be in your lease, except in one way that I'm telling all landlords, and it doesn't even require a modification of your lease. It just requires that you fill out the notice section. Because guess what? Although for years in the state of Texas, this might be different in other states, which is why I always mention that, for years in the state of Texas, it has been improper for a landlord to deliver a notice to vacate to a tenant through email. If that's the only way you sent it and you didn't send it in one other way that is approved by the state, your eviction case was dead. And so now the law does allow, as long as the agreement between the parties, i.e. the lease, specifically the notice provision, allows for notices to be sent by electronic mail, you're in as long as you have written approval for it. So the only change I would suggest making is making sure you filled it out. And like I said earlier, you're going to want a personal email, work email, if you've got a tenant portal or some kind of app that you can use to communicate. Texting, that's my least favorite of these options, but it's an option. It's an electronic transmission of your notice. If you can get them to agree in writing, in the lease, in the notice section preferably, to receive notice in this electronic form, then yes, you can actually send a notice to vacate through this electronic means, and it will be perfectly valid come January 1st, 2026. As far as altering your lease terms in any significant way, first, without seeing your lease, I couldn't tell you if it was deficient or not, but presuming it's a perfectly valid lease right now, it'll be just as valid in January of 2026. I don't foresee anything except, that notice provision and allowing for even your notice to vacate to be sent in an electronic means. That's really gonna help a lot in the eviction processes. So that's the main change that I would suggest. If you've got a lease and you are in Texas and you are otherwise unsure as to whether or not it is perfectly valid or, really still up to snuff now that the law has changed again. The last overhaul was in 2013. It's been 12 years. But if you've got a 20-year-old lease and don't know whether it's still good law, I strongly suggest that you get it reviewed by a landlord attorney like myself. My phone number and my email address are here on the bottom. If you've got a 1 or 2 or 3 page lease and you're renting out property in the state of Texas, I can tell you point blank, it's probably not a very good lease. And you're going to want something that protects you better. Reach out to us. We'll be happy to assist you with a lease that we draft tailored specifically to you and your property and help you understand your lease and how best to utilize it for you, particularly as the laws are changing. We'll put something powerful in your hands and guide you along the way should you ever need an eviction. We're here, your one-stop shop for leases and evictions should the need come. Alrighty. War Clan writes, oh, that was War Clan. I thought that was Wanda. If they paid rent, you accepted the judge. Oh, no. I'm sorry. I'm getting behind on my messages here. War Clan does write, if they paid the rent and you accepted it, the judge will invalidate the eviction. Again, maybe if you've got a written agreement or some kind of written settlement agreement, maybe not. We write those all the time. If they want to pay the rent, let them pay it, and to the judge in the court. I don't know about that. Again, we sometimes write settlement terms that tenants can pay to the landlord X, and if they do, we'll do Y or Z. Sometimes it means dismissing the case. Sometimes it means delaying on the writ of possession. There's all sorts of things you can write into an agreement that a court will honor. But if you don't have anything in writing, again, you're just creating a mess. Wanda goes on to say, if you give a tenant a mutual agreement to terminate the lease and tell that as long as they move out by, in this case, 12/31/25, would that be considered making a new deal and the eviction to be thrown out? Yes, because if you've made a previous demand for possession, but now they have possession extended all the way through the end of the year, then a current lawsuit for possession probably doesn't make sense if that agreement was entered into after your eviction filing. So, entering into new terms after the filing of an eviction, in the law, we refer to this as a novation. If you've got one set of terms and then you introduce a new set of writing, a new agreement in written form, then that novation replaces the previous terms. And so now the latest agreement is the controlling agreement. And if they've got possession until the end of the year, then your eviction, which predates those new terms, is probably no longer valid. How much are your leases? That's a good question. So right now we are running leases at $650, and that's both drafting the lease, sitting down with you and modifying it, tailoring it to you. That comes with additional addenda, pet agreements, mold addenda, other things having to do with floodplain issues and even death designations. So you'll get all of that included, as well as a 30-minute session with an attorney to make sure it is tailored the way you want it. If you want some changes, we'll make that. And you get this in a digital format that you can tailor any way you want. So you want to put your own letterhead across the top. You want to modify the format or the layout to suit your needs. And you get to use it over and over and over again. You don't need to be part of an association, like maybe the Texas Association of Realtors or the Texas Apartment Association that requires that for their leases to be valid if you're using them. You don't need a realtor. You own this, and any lease that you have complete control of is always the best lease, especially if you can later modify it and you've got the digital copy. So if that's something you're interested in, let us know and we'll be happy to set that up. So War Clan continues to write, if you want to evict for people not authorized to occupy the premises, what do you need to prove it for having successful eviction? Well, the authorization is going to hopefully be in a written lease. So if you've got a lease that says, tenant 1 and tenant 2 are permitted to be there, but tenant 1 and tenant 2 welcomed in occupants 3, 4, and 5, well, the best thing that you can do to lay a foundation for a lawsuit like this is to send notice of default. You send a notice of default saying, you've got unauthorized occupants there. I'm going to give you 3 days to get rid of them, or else I may proceed with an eviction. If you go back on day 4 and they still got them there, you say, look, I'm going to send another notice to you. Get rid of these unauthorized occupants. They don't belong here. And then you send it again. Now you've got a pretty strong claim that they have violated the lease and have failed to adhere to its terms. I think on that basis, you've got a pretty good claim. Even if they're paying the rent, you've got a good claim to recover possession because of this major violation. So that's how I would set it up. I would give them an opportunity and then follow up and make sure that they've done it. And if not, I would follow up eventually with a notice to vacate. I preach 3 strikes and you're out. If I've given you 3 notices to cure some default and you haven't done it, you got to go. Let's see. All right. I've got, let's see, a few more questions. Tenant did not agree with the agreement. We did not sign it. Well, unfortunately, if you accepted money, you agreed to something, and that ambiguity, unfortunately, it could be problematic. So by accepting some amount of money, that's evidence of some tacit agreement to something. They're going to say, she accepted money in exchange for letting me stay. And without something in writing, good luck proving that that wasn't the case. It might win over the judge. And so that's why we always want to do it in writing. No new termination of lease was placed or signed. I simply told tenant, sign this if you want extra time. We never signed it, but can this be held against me? No. If there was simply an offer that was made that was never accepted, that's not even proper evidence at trial. No, it should not be able to be used against you. No money was accepted. Great. If no money was accepted, then it doesn't sound like, even though an offer was extended, that any offer was ever accepted. There should be no modification. In that case, you should be able to sail through your eviction. The fact that you were discussing settlement, but no settlement was ever reached, doesn't change the fact that you still have the right to evict. Tina Wynn writes, our eviction case was reset due to a constable were not able to serve the tenant. She doesn't answer the door, so how long is that handled? Well, if you're talking about a writ of possession, they don't have to answer the door for the writ of possession. The constable should be able to just tape it to the outside of the door. If you hired the constable to go and place it in their hand, that's a different thing, because there has to be a hand present for the constable to put it in their hand. Now, it's been my experience when the constables undertake this, along with going to put it in their hand, they usually also send it in the mail. I would check with the constable to see if the constable you hired to serve this didn't also send it by mail, because that, in the state of Texas, is a perfectly valid form of delivery. The problem is, if it was only sent by regular mail, how are you going to prove that it got there? Because of that, we tend to tell landlords, you should send, if you're going to use the mail, 2 copies. One of them certified, one of them regular. The certified one you can track, and if you mail them together, and even if they don't answer the door, you can track when service of the certified letter was first attempted. And here's what we know. If we mail both of them together, they are delivered together. So that if this one is attempted delivered, even if unsuccessfully, we know this one on that same date was actually put in the mailbox. As long as they've got a mailbox, we use that as day 0. Then we count 1, 2, 3 on day 4 or after we file. So that's the way we resolve that, is we send it by regular and certified mail. We track the date of delivery or attempted delivery, and that's the day that the regular mail got there. And that's the way we prove those cases up in court. Wanda, you are welcome. I'm glad that helped. Not a writ of possession. We just in the first stage of eviction. So again, follow through with your constable and see if the constable mailed it. Sometimes the courts are going to take the word of the constable if you've got a receipt from them showing that they mailed it. If that wasn't the case, then you may want to just begin the process over. Send the notice to vacate by regular and certified mail. Keep your receipt of that mailing, because that'll be good evidence of your delivery of the notice. We have date in court and it was reset. Okay, now that seems to be not the notice to vacate. That seems to be the eviction petition itself. And this is very common, where the court, through the constable's office, tries to serve notice to the defendant, but they can't because they don't answer the door or they're never home. Well, the court will generally, in the state of Texas, issue an order for alternative service. And the constable will then go back out and literally tape the notice to the outside of the door and serve it through the mail. That counts as service. They don't have to put it in their hand the second time if the court authorizes alternative service. And as long as they get it at least 6 days in advance of the trial, you can go to trial, no problem. And so the constable will swear in an affidavit to the court, I delivered it on date X. Again, as long as the trial is at least 6 days after that, you are golden. In fact, in January, that shrinks to only 4 days. So that should speed up the process of many cases, again, starting January 1st. All right, let's go back. We've got another question. This is a prefab question that we received. Is the Section 8 housing voucher program considered a federal program that you must give a 30-day notice to pay or quit instead of the traditional 3-day notice to pay? Okay, so Wendy has asked this question. And so, yes, Section 8 housing is a program from the Department of Housing and Urban Development. That is a federal program. The 30-day notice to pay or quit is not a requirement necessarily that's addressed in what I'm about to say, but a 30-day notice to vacate is presently required when you've got a federal housing program by the CARES Act of 2020. In March of 2020, the federal government passed the U.S. CARES Act, and in that, there was a requirement if you were receiving federal funds or for like Section 8 housing or some other federally funded program, or if the loan that you had for your mortgage for your rent property was federally backed by Freddie Mac or Fannie Mae, then you were required, based on the CARES Act, to give a 30-day notice to vacate for any eviction. That has been the law since March of 2020. And so, yes, Section 8 housing is a federal program, and it is subject to the U.S. CARES Act until the end of this year, because, as I mentioned prior, the Texas Property Code will be amended as of January 1st, 2026. And Section 24.005, subsection C1, says all of that CARES Act stuff goes out the window, no more 30-day notice to vacate. So if you can hold out till January 1st, yeah, you can stick with a traditional 3-day notice to vacate unless your lease requires something different. I don't know what your lease says, so I can't say whether your lease requires fewer or more days. We always say if your lease has fewer than 3 days, stick with 3 days. Judges are fine with 3 days. Some judges are not fine with less than that, and they will kick your case out. It's not worth it. Even if your lease says, I can give you 24 hours notice, stick with 3 days. If your lease requires more, then do that. But yes, for now, until December 31st, 2025, the Section 8 voucher program is a federal program. It does require, because of the U.S. CARES Act, 30-day notice for now. State law will adjust on January 1st, and that will no longer be the case January 1st, 2026. So, all right. Tina Wynn says, thank you, Ernie. You are very welcome, Tina. I appreciate you contributing your question. Wanda says, how would the court know if you have a Freddie Mac or Fannie Mae mortgage? That's a great question. Now, during the pandemic, there was money all over the place, and some of that money went to local legal aid programs. And during that time, there was a legal aid attorney there who, with his laptop, whenever a case would go up, look up the property address and say, oh, federally funded, federally backed mortgage, because there are websites that'll show that. And so because of that, many evictions stopped in their tracks when a 30-day notice was not given. Now, the judge may just ask you point blank, do you have a federally backed mortgage? And it may go, especially a tenant-leaning judge, the judge may ask you, do you have a mortgage? Yes. Do you know whether it's a federally backed mortgage or not? And if you say, I don't know, well, then you don't know if you needed to give a 30-day notice. Unless you tell me you do know, I'm kicking this case out. And believe it or not, that can happen. So we screen all of ours before, and we ask all of our landlords, have you confirmed with your lender whether you have a federally backed loan or not? Because we know that that is a remote possibility, but a possibility nonetheless. And so because it can happen, we always try to prepare for that as a possibility. And so if you don't know, ask ahead of time. Between now and the end of this year, it's going to be a thing. Starting in January, it's no longer a thing and not something you really have to worry about. James writes, some of our local JPs are giving workshops for landlords when coming to court. They make it clear they cannot give legal advice, but they are very helpful. Yes, that does happen. Sometimes judges will give helpful advice to landlords, and some of them will give helpful advice to tenants. I'm here essentially helping landlords the best I can. I hope you guys are benefiting from these lives. We're done with all of our questions, both from the chat and from the preset questions. I want to thank all of you who joined the chat. Those of you who stuck around all the way to the end, I appreciate all of your contributions and hope you have a great rest of your week. Come see us next week where we will be talking about can a tenant terminate a lease if there are repair issues at move-in? We had several people asking about this here recently, and I want to answer your questions. I want to talk to you about what happens when there are repair issues at move-in and whether or not the tenant has a right. But between now and then, I wish you guys the best. I hope you have a wonderful week. See you next week, Ernie. That's from James. Thank you from Alexander. I appreciate you guys. You guys have a great week. And until next time, happy leasing.